another session where we are going to be looking at the Consumer Protection Act of 2005. And although the title speaks about exemption and exclusion clauses, we would have dealt with exclusion clauses and exemption clauses under the heading of the content of contract. So we won't be focusing on exclusion or exemption clauses, but we shall definitely be looking at the Consumer Protection Act of 2005, and we'll be looking at the provisions of the Act. So in relation to the assessment, we are interested in the knowledge of the provisions and the type of protection that consumers are accorded by virtue of the Consumer Protection Act. So that it's important and for you to get the legislation, and we will be highlighting the relevant sections of the legislation. So as you can see on your screen there, there is a commission that has been established under the Act, and that commission is called the Consumer Affairs Commission, and it is a body corporate. For those of you who are going to go on to do company law, when we speak about a body corporate, what we're really speaking about is that it is a separate legal personality that has been incorporated. So that is important. So Section 5 of the Consumer Protection Act of 2005 establishes the Commission. And what are the roles and functions of the Commission? That is also a matter of importance. So as you can see on your screen there, that the Section 5, subsection 1 of the Consumer Protection Act makes it very clear that there shall be established for the purpose of this act a body to be called the Consumer Affairs Commission, hereafter in this act referred to as the Commission. It shall be a body corporate, and of course the definition of what body corporate is found in section 28 of the Interpretation Act. And I've explained at the top what we mean by body corporate. That is a separate legal entity. That means it can sue or be sued in its own right. It can enter into contracts, and it is treated just as how we would treat a natural person, but it is an artificial person. Then the functions of the Commission are dealt with under Section 6 of the Consumer Protection Act of 2005. And what does the provision say? Well, Section 6 subsection 1 and makes it clear that subject to subsection 3, the Commission shall, and this now is the functions, carry out at the request of a consumer who has been adversely affected such investigations in relation to the sale of goods or provision of services as will enable it to determine whether the goods were sold or the services were provided in contravention of this act, and thereafter to make such report and recommendations in connection therewith as it thinks fit to the minister, and that is the minister who is responsible for commerce. So the first function of the Consumer Affairs Commission is to investigate, and that investigation, as you can see by the section, is to determine whether the service provider or the goods provider is in contravention of the Consumer Protection Act. And this investigation is triggered, of course, by a consumer who lodges or files a complaint. The second function of the commission is found also in section 6 subsection 1 paragraph B, and it outlines there that again it is investigative, but this time it is on the initiative of the commission itself, and this is in relation to the availability of goods of any class or description as it thinks fit, and make such report and recommendation as it thinks fit to the minister. So, interestingly, we are in a new dispensation because of COVID-19, and persons have been complaining about price gouging and so on, and the availability of certain products, particularly hygiene products. And if it is that the commission is of the view that there is price gouging, then they can initiate an investigation on this particular section and make whatever recommendations they think to the minister. So the third function of the commission is to promote the development of organization formed for the protection of the consumer and ensure that they fulfill the criteria listed in section 4 of the Act. So, encouraging the formation of consumer protection bodies and ensure that they are trained. The fourth is found in paragraph B of section 6 subsection 1 of the Consumer Protection Act, which is to collect, compile, and analyze information in relation to any trade or business. So general information. And again, when you operate a market economy, then information is important, and the Consumer Protection Commission is to gather information. Fifth is found in paragraph E of section 6 subsection 1 of the Consumer Protection Act, and that is to provide information on the rights of consumers and any other consumer education. So again, information from a different perspective, which is to allow consumers to know what their rights are, and consumer education. So obviously, it is felt that informed consumer will have value. Then sixth function is found in paragraph F, where the role there is implement education programs for the benefit of consumers, suppliers, and service. So it's a continuation of the public education ethos. So if one were to categorize the function of the Consumer Affairs Commission, one could say it's investigative and it is educational, in terms of two broad categories if one were to do that. But obviously there are other roles, because it is also to provide analysis to consumers. So we have looked at several functions. So yet another function, and I think this is the seventh function, is found in paragraph G, and this is seek to resolve disagreement between consumers and providers. So one could say that it has a mediatory or dispute resolution role. And then we have paragraph H, which indicates to carry out such other function as the minister may assign to the commission from time to time. So this is sort of an omnibus clause here to give it some flexibility. The minister may want to be advised, the minister may want to have information or data at his disposal so that he can make certain policy decisions, and the commission will certainly support him where that is concerned. So section 6 subsection 2 of the Act makes it clear that the commission has discretionary powers in terms of exercising or discharging its function, and because it is a body corporate, it can enter into any transaction that the Commission may deem to be necessary to carry out its proper functions. So again, as I've said to you, as a body corporate, it can engage in decision making. So Section 6, subsection 3 of the Act empowers the Commission to investigate, and Section 7 to 12 sets out the modalities of that investigation. And again, those are sections that you can, in your own time, create yourself. So we go now to the main provisions of the Act, which are geared towards consumer protection, and these include Section 18, which speaks about the duties of providers and consumers. So we can take from that it is not just the consumer that is being protected here, but consumer also has rights, or also have responsibilities, I should say, or obligations that they too must fulfill. So the first line of defense when it comes down to consumer protection is the provision of information, and that is found in Section 18, subsection 1 of the Act. And as you can see on the screen, when we look at Section 18, subsection 1, it speaks about the provision of information. That means the item must be packaged, must be labeled, there must be a description of the goods, and this must be written or verbally in English, and that is the language that we use here in Jamaica. And every bit of relevant information that relates to the good must be included in the item. And then, of course, the place of origin, the price must be in Jamaican or should be in Jamaican, and even if it is quoted in American or any other currency, the equivalent Jamaican currency should be there. If it is an item that is to be assembled, the components, the directions in terms of it must be used, the weight of it, size of it, and of course, if it is to be assembled, then instructions for it to be assembled must be included in the information, and this is required by Section 18 of the Act. And as you can see there as well, if we are talking about services, then if there are professional fees, these should be made known to the consumer upfront. So, it's like if you take public transportation or you take a chartered vehicle, it's prudent to ascertain what the fare is before you board, so that you are clear what the contract price is. So likewise with professionals, and they too are called upon to provide information regarding their fees, so that when people utilize their services, they are fully aware of what to expect. Then subsection 3 of Section 80, in relation to the provision of information, makes it very clear that the provider will be liable if they do not provide information to the consumer and there is any damage to the good, whether this be directly or indirectly as a result of that lack of information. So they will be liable. And subsection 4 of Section 80 imposes a sanction on the provider who fails to provide information to the consumer. And here the matter is a matter for the parish court, the parish judge, and if the service provider is found to be in violation of Section 18, then the fine upon conviction is 200,000 Jamaican. That brings us now to section 19, which has to do with the measurement of goods. And remember, what we're looking at here is the Consumer Protection Act and how the provisions provide protection to consumers. So section 19, subsection 1, makes it clear that a consumer shall at all times be entitled to check the weight, volume, or other measurement of any goods that he may be purchasing, where the weight, volume, or measurement of the good materially affect and determine the price. So once there's a correlation between the price and the weight or the measurement, then clearly care has to be taken to ensure that the proper measurements and the proper weights are realized. So here, subsection 2, in relation to subsection 1, makes this in relation to standard of measurement and volume, that this is not something that is arbitrary, but it is governed by the Weight and Measures Act. And the provider must conform to these legislation to ensure that the consumer is getting value for money. So subsection 3 of section 19 obviously makes it an offense if the provider does not give you the proper weight or the proper measurement or the proper numbers to be delivered. And if you pay for a dozen and you get 10, then that is an offense. If you pay for a pound and you get half pound, then that also is an offense. Measurements must be precise, and where this type of unethical behavior is detected, then it is a contravention of the section and it is an offense, and the liability there on summary conviction before a parish judge is a maximum of 500,000. So that brings us to section 20 of the Consumer Protection Act of 2005. And here, the responsibility of the provider is to give a receipt to the consumer. And section 20, subsection 1 makes it very clear that where a consumer purchases goods or services from a provider, the provider shall, notice the word shall, that's mandatory, give the consumer a receipt, and that receipt should be following elements on there. So the receipt must have the amount paid by the consumer, must have the date on which the purchase was made, must have a description of the goods or services sold, and if it's professional fees, then professional fees to be charged, and any other relevant information that is required. And the receipt is essentially proof of payment, proof of purchase. If you want to say it's a title for the goods. Then, of course, we have subsection 2 that makes it clear that once the purchase has been made, the receipt must be issued, and that receipt, as I've said just now, is adequate proof of purchase of the goods and services. And if there's a need for a refund, then that receipt will become very important in establishing purchase and therefore the entitlement for a refund. So subsection 3 goes on to make it clear that if no receipt is forthcoming, then this is an offense, and on summary conviction before a parish judge, the fine will not exceed $50,000, but then there is a term of imprisonment for 30 days, and you can either be fined or you can be fined and confined. So here is the first time in the legislation that we are seeing now not only a fine as a penalty or a pecuniary fine, but certainly the threat of imprisonment, right? So it demonstrates how important it is for service providers or providers of goods to give receipt. Now, section 21 speaks about warranties. Now, you remember when we were doing content and we came upon condition and warranty, I made the point that in the context of contractual terms, warranty in that context was not what you would get at Singer or court. Now, here under the Consumer Protection Act, when we speak about warranty, we're speaking about what you definitely would get at courts and Singer if you go there to buy anything or any store that you're purchasing items that could go bad or could be defective, right? So section 21 speaking about that type of warranty, right? So section 21 subsection 1 says subject to the standard provisions of warranties, a provider shall issue explicit warranties in relation to his goods or services, as the case may be whether the goods are new or used and whether the service offered is the repair of any appliance, furniture, equipment, or other. So here the warranty applies both to goods and to services, right? So if you're a repair person, then you give a warranty that the repair will be good for X amount of time. So any warranty given by the manufacturer, whether local or foreign, and attached to any good or services sold or provided, as the case may be in Jamaica, shall be deemed to extend to the provider in Jamaica, who shall be liable to the consumer in relation to such warranty. So that is section 21, subsection 1, dealing with warranty. So not only are local service providers and suppliers of goods to provide warranties, if they import these goods, then they should ensure that warranties are provided by the manufacturers, and those warranties will be applicable here in Jamaica as well. So the provision continues with subsection 3, which says that where a provider is liable only for free replacement of parts under a warranty agreement, provider shall not require the consumer to use the services of the provider in effecting the repair to the equipment. So you can't be compelled to use the service provider repair persons or they themselves if it is that their warranty is in relation to replacement parts. Now, it speaks about implied warranties in the absence of explicit warranties, and that these shall apply to all used goods and to repair of all goods. In the absence of any explicit warranty between the provider and the consumer, the act implies warranty. So subsection 5 now speaks about where repair services provided and replacement of defective goods, and it says very clearly there that there shall be an implied warranty. So this is again mandatory in relation to the replacement of goods, and this shall be in a reasonable time, and that the implied warranty is applicable to contract for sale of which shall apply in relation to repairs and replacement. So again, you know, the warranty that we're talking about here is, for want of a better word, assurance that if the products are defective, then the provider will either replace them or repair them, and if it is services, that those services will be offered to a high standard. Subsection 6 now speaks about absence of explicit warranty, and of course that if there is no explicit warranty, then the provider has a discretion, and the implied warranty is 6 months in relation to parts and labor, and of course will be subject to any standard warranty that attaches to the transaction. So that brings us to section 22, which is damage resulting from use of service or goods. So remember, we're looking at the Consumer Protection Act of 2005, and we're looking at provisions that seek to protect the customers and the duties of providers as well as the duties of consumers. So here, section 22, subsection 1, says subject to subsection 2, what the providers should do if there is damage resulting from use of services. So the first thing is that they undertake to provide a consumer a good or service upon payment of a fee. That's the first thing. And the second thing is that it provides the declared benefit attached to the service or use of the goods. And if there's an injury or any pecuniary loss that is sustained by the consumer, as long as that consumer is not contributory negligent, then the provider is going to be liable. That's essentially what is happening here. So once the consumer has complained to the provider and there is a complaint to the commission that substantiate that they have suffered loss or damage, then the provider will be called upon to pay the consumer reasonable costs incurred by that consumer in correcting damage that has been caused, right? And this should take 7 days. So that is what paragraph B is saying. So what is happening here in relation to damages resulting from use of services or goods is that the consumer makes a complaint to the provider, and they will also make a complaint to the Consumer Affairs Commission, who will determine whether the complaint is valid, yes or no. And if it is that they have determined that the consumer has suffered loss, then the provider will be called upon to compensate that customer, and also that there's a time frame within which the compensation should take place, which is 7 days. Now, if the provider is unable to initiate payment within that period, then they can apply to the commission for an extension of time to allow them to make the payment. Now, the provider shall not be relieved of liability if the consumer fails to avail himself of some other good or service that may be recommended by the provider of the primary good or service as supplementary or complementary good or service. Now, if he does provide complementary goods or service that fail to function effectively, then in those circumstances they will not be absolved. So what it therefore means is that the provider can offer to the consumer a replacement or an alternate product. It is up to the consumer whether they'll accept that, yes or no. And if they do offer it, then they have to ensure that that complementary good or service is equal to or better than, some may argue, the original item had been bought. So if the provider fails to rectify and remedy the situation, fails to compensate the consumer in a timely manner, or fail to offer them some alternative product that is satisfactory, then as we can see here, that upon summary conviction for a resentment will be fined, not except $500,000. So section 23 speaks about damaged goods sold to consumer. We're talking about consumer protection, and this is where now the quality of the good become important. So as we can see by virtue of section 23 subsection 1, that where any goods sold to a consumer fails to provide to the consumer the benefit and uninterrupted enjoyment for which it was intended, and where the failure is determined by the commission after consultation with the provider not to be due to apparent negligence or abuse by the consumer within the comprehensive warranty period, the relevant provider shall be responsible for its replacement or repair at no cost to the consumer. So notice here that the warranty period is of import. So if there's any defect that is detected by the consumer, they need to act upon it very quickly in relation to the warranty period to ensure that they can have their item replaced at no cost to them. And again, recognize the investigative role of the Consumer Affairs Commission, because it says after consultation with the provider. So it therefore means that the consumer complains to the commission then goes to the service provider or the goods provider and makes an inquiry or investigation. And if they determine that the complaint of the consumer is just and it is within the comprehensive warranty period, then the provider will be able to pay. Now, when it comes on to the business here of repair, then the provider must return the good to the consumer in a fully repaired and functional state in such period after receipt of the good for replacement or repair as the commission after consultation with the provider shall consider appropriate. So remember that when we looked at section 22, there was a time frame of 7 days within which to make good on any refund. And here in paragraph 23 or section 23, what we're seeing here is that there's some discretion in terms of time, and it is the commission that is going to determine what is the appropriate time for that repair of goods to take place. So if the goods are not returned to the consumer within the period determined by the commission, provide the consumer with a temporary substitute of comparative value for the consumer's uninterrupted use until such time as the consumer's good is replaced or repaired and returned. So here an onus is being placed on the provider to minimize the inconvenience of the consumer by providing them with a replacement item or an interim item until they have their actual product back. So if this section is breached, then again the jurisdiction here is the parish court before a parish judge, and the maximum fine is $200,000. So that brings us to section 24, which deals with return of defective goods. So section 24 subsection 1 says subject to subsection 3 and the subsection 4, where a consumer is encouraged to acquire goods by the provider's declaration and description of the goods, and the consumer subsequently discovers that those goods are defective or different in a material particular from those declared or described, the consumer may return the goods to the provider. Now I pause here because bear in mind that now we're talking about sale by description, which we would have seen under Sales of Goods Act. So this here is a complementary provision to the Sales of Goods Act in terms of the protection of the consumer. So if it is that the good does not conform to the description given by the provider, then the consumer can return or may, because this is discretionary, the goods to the provider, right? So the provider has a responsibility to ensure that what they are, uh, representing is indeed factual. The description must match. So the provider shall immediately offer the consumer in exchange for return goods monetary compensation to the value of the goods or such other amount as may be agreed between the consumer and the provider. So here there is what I would want to call restitution, and in relation to return or refund on goods returned to a provider pursuant to subsection 1 shall only be made where the goods are returned to the provider. So here is the way now, or the requirement for returning this goods or these goods. So the first thing is it must be in the condition they were purchased, and you will, from your own experiences, might have had to return items you have bought, and one of the, or the provider will say to the consumer that if you're returning it, you must bring it back almost as you got it. So you must bring back the wrapping, you must bring back the receipt, and uh, the different component parts if it is something to be assembled. And this is because the act requires that that be done. So there really shouldn't be any further damage to the item than the defect with which it was bought, and these things will be subject to investigation. And if there's a dispute as to the condition, so the provider may say, well, that's not how we gave it to you, and the customer is saying, well, that is how we got it, then the commission will invoke its investigative power to determine what condition the good was in fact in, and once it has determined that it was defective from the provider side, then the provider will have to make a refund or a replacement. Now, the subsection 4 of the Act makes it clear that a consumer who acquires a good that in every way is similar or identical to one requested or described and declared by the provider shall not be entitled to a refund if, having left the place from which the provider sold the good, the customer or consumer for any reason decide that he no longer wants it. So again, if the provider, in lieu of refund, is providing a replacement and that item is identical, but the consumer, for whatever reason, rejects it, then the provider is not obligated to refund. Right? Now, if the provider violates this section, they commit an offense, and again, the jurisdiction is the parish court before a parish judge, and the maximum fine is $500. So that brings us to section 25, which deals with return of electrical goods. So section 24 deals with return of damaged goods, and section 25 is specific about electrical goods. So here, section 25, subsection 1, says subject to subsection 2, these provisions apply. So a consumer purchases any electrical good believing it to be fully functional and operational. Upon attempting to use it, the customer discovers that it is faulty or non-functional. Consumer shall, upon returning the good to the provider, they are going to get an exchange of the faulty good for a new functional similar to the good free of cost, or a refund of the amount paid for the good if the provider is unable to establish that the good was damaged as a direct result of the consumer's action. So that's an important point, very short but important. And again, it's important when you're going into a store to determine from very early what is the return policy of the store. And When it comes on to electrical and appliances, electrical equipment and appliances, you will see that the store tests these things before you leave with them. So the light bulb, they screw it in to ensure that it comes on. It is a remote control toy. They will put in the batteries and ensure that it works, so that that is in a sense to minimize their exposure. Now, approved and non-approved services, that is section 26. And section 26, subsection 1 states that a provider shall only provide such services as are approved by the consumer, and shall not require a consumer to sign an open-ended commitment to pay for services which, in addition to those contracted, may, in the provider's opinion, be necessary or appropriate. So, in other words, the provider shouldn't impose themselves on the consumer unnecessarily, right? So a provider who offers repair services shall disclose to the consumer any and all additional related repairs that he deems necessary for the consumer to enjoy reasonably long and uninterrupted use of the repaired goods. So again, if we take mechanics as an example, you may go to the mechanic figuring that you have you need an oil change, but then the mechanic recognizes that your transmission isn't working. So rather than just give you an oil change, what this provision is saying is that they should bring to the attention of the consumer that, look, you need a transmission, and allow the consumer to be aware of the extent of the repairs that are necessary. So in applying or offering repair services, the provider should obtain a written indemnity from the consumer if the consumer chooses not to require the provider to effect the recommended repair. So the point being made here is you go in, as I'm saying, for oil change, but it turns out that you need a transmission. The section is saying that the peer service provider should advise you that you need a transmission. Now, if you choose not to get the transmission, then that is a matter for you, the consumer. The provider will not be liable because the provider will discharge their function by explaining to you what the extent of repair is. Now, if the provider fails to do that and give you an oil change and you go out there and your transmission mash up, then they will be in contravention of this particular provision in terms of provision of information, and as such they would be liable on summary conviction for a parish judge to a fine not exceeding $500,000. So to the extent that we are looking at sanctions under the Act, the only breach that attracts imprisonment up to this point is the failure to provide a receipt. So what about businesses that are offering repair services? And this is treated by section 27 of the Act. So here, section 27, subsection 1 says businesses which offer repair services to consumers shall keep records, and these records shall state the name and address and telephone number of the consumer, reasonable, accurate description, that is, of the good to be repaired, including the identification number or mark, the replacement value of the good in its present state as agreed with the customer, an estimate of the labor and other costs to be paid by the consumer in respect of the repairs effected, the date on which the good was received for repair, and the date on which the good will be ready for delivery. And a copy of such information shall be given to the consumer before repairs commenced. So it's important to note all of these requirements for persons who are engaged in business or repairs, and if business does not offer these, then they are in breach of the section, and if they are convicted before a parish judge, they will be fined $500,000 as a maximum fine. It could be fined less because it said not exceeding $500,000. So it's part 6 of the legislation speaks about unfair contracts, and again, this is to protect the consumer, recognizing that sometimes there is what you would call a asymmetrical power relationship between the provider of goods and services and the end user, the consumer. So, in this regard, the important thing is that the act is not concerned with whether the provider is deliberate, because as you can see there, based on section 36, there's a duty that is imposed on the provider to be fair, right? And if it is that they acted in a way that was unfair, it doesn't matter whether they were intentional or not, whether they were deliberate or not. Once it is that the consumer is put at a disadvantage, then they are going to be liable. Then section 37, beg your pardon, deals with exclusion or restricting liability by contract. Now, as I said at the top, that we weren't going to detain ourselves with exclusion clauses because we are looking at exclusion clauses in the context of common law, in the context of the content of contract. But here, we're talking about excluding or restricting liability by contract. So this is now statutory, if you will, in relation to the exhibition or exclusion clauses. So here, section 37, subsection 1 makes it clear that a person shall not, by reference to any term of a contract, notice given to person generally or particular persons, exclude or restrict his liability of or death or personal injury resulting from negligence. So what this is actually doing is making it very clear that exclusion clauses or limitation clauses are not applicable to liability arising from the death of somebody and from personal injury, which results from negligence. And again, that is designed to protect the rights of consumers. And here, subsection 2 says that where there is loss or damage, a person shall not so exclude or restrict his liability for negligence except insofar as the term or notice satisfy the requirement of reasonableness as provided for in section 43. So again, this is seeking to qualify the disclaimer that personal injury and death are excluded from limitation or restricting or excluding clauses. The question that arises, is it reasonable for liability arising from wrongful death, liability arising from negligence that causes personal injury, are those reasonable to have to be excluded or to be limited by contract? So here, the question is, did the party voluntarily accept any risk? So an important sector that this provision would apply to are amusement parks. So if you go to Jam West to ride the ATV, and you fall off and are injured, then the question is going to be, was it reasonable to exclude or to limit the liability in these circumstances? Likewise, if you go to Six Flags and you're on one of these roller coasters and God forbid it malfunctions and somebody dies or is injured, or you go on the water slide and you because of design rather than stay within the belly of the slide, you sail out and are injured, then you would have signed an indemnity for, because usually they ask some questions. Do you have any heart condition? Do you have any ailment? Do you have any back problems? And if you are not honest and frontal about your conditions, then you may find that you um, are limited in terms of the recourse that you may have. So I also like to point out that there's nothing absolute about an exemption clause or anything absolute about um, a limiting or restricting liability clause, because again, each case will depend on itself. One of the issues that may arise is the question not only of reasonableness, but also the question, did the person understand what they were signing? Did they were they properly advised? The question that may arise. So you can take your time and look at section 41 of section 43, deals with reasonableness, and I just spoke about that, gave you some examples of how that could be um, determined, circumstances be reasonable to do so. So we will hold it there in relation to consumer protection. Relatively straightforward topic, and the examiners are usually concerned either with the um, role of the commission, what are the functions of the commission, and we see there that it is to investigate, it is to analyze, it is to provide public education to consumers, to promote consumer organizations, and so on. And then, of course, we have looked at the actual provisions of the Act itself, and we see that there are fines associated with breaching the various provisions. An examiner could be interested in knowing knowledge about what fines are applicable to each section, but more importantly, what they are interested in is what are the consumer protection provisions under the Act. And since this is statute and we have not relied much on case law in this context, then knowing the provisions would be advantageous. So we will hold it there, and when we come back, we look at the Fair Competition Act and then close out the consumer protection provisions, and that, I believe, will be the final topic to be covered.